Okay, so it is 1 o'clock. I think we'll go ahead and start the program. My name is Sean Murphy. I'm a professor here at GW Law School. I'm a not-on professor of international law. And it's a great pleasure for me to introduce our speaker for today, Ambassador Rolf Einar Fife, who is currently the special advisor to the Secretary General of the Norwegian Ministry of Foreign Affairs. He is a graduate of the University of Oslo, and after serving in 1984 to 85 in the Polar administration of the Ministry of Justice, which sounds very cold, he joined the Norwegian diplomatic service and went to warmer environments in the Middle East and then to the United Nations in New York. From 2002 to 2014, Ambassador Fife was Director General for Legal Affairs of the Foreign Ministry, and in that capacity, he was the chief Norwegian negotiator for the maritime delimitation that was concluded in 2010 between Norway and the Russian Federation. Further, he was elected as the chair of the Council of Europe's Committee of Legal Advisors on International Law, also referred to as the CADI, and served in that role from 2009 to 2010. From 2014 to 2019, Ambassador Fife was Norway's ambassador to France. And after that, from 2019 to 2023, he served as Norway's ambassador to the European Union. He is currently a member of the UN International Law Commission, joining it just last year as I was leaving, unfortunately, so our paths did not cross there, but we are both members of the L'Institut de Droit International, so it's a great pleasure to have that association. His lecture today will be on democracy, authoritarianism, and the international legal system. Please join me in welcoming Ambassador Fife.
Thank you so much for this introduction. It was much too detailed, but I'm delighted to be here. And I'd like to share with you some reflections on those topics. I will do that in a personal capacity because with my current job, I don't want to appear as though I'm stating position of the government or Norway. I think it's compatible what I'm going to say with what Norway believes, frankly, about democracy and authoritarianism. But those are my personal reflections. I find it extremely stimulating to be here. And I would, at the outset, like to thank you, Professor Sean Murphy, and salute your important contributions to international law, not least the International Law Commission, where you served until recently. You have left a mark which is very profound importance and inspiring to me as a new member of the International Law Commission. So let me say that what you have been doing is both inspiring and has left and is leaving lasting effects. Now, you are, I think most of you have either studied international law or are studying international law. And I wonder if any of you have actually picked up a manual. How many of you are Americans or US nationals? And how many of you are not? So it's a very balanced kind of composition here. So before coming, I checked different manuals or handbooks of international or general international law in different languages. So I went to the indexes and tried to find what they stated about democracy or authoritarianism. And I must admit that usually those two words are not to be found in the indexes of those manuals. And if democracy is mentioned, I'm now thinking of basic manuals where described how the international legal system works. If democracy is mentioned, it's usually, at least the references I found was that it's linked to the constitutional autonomy or independence of each state. So basically, international law, the first impression one gets is that this is a legal system where the equal sovereignty of states, the right of self-determination of people's principle of non-interference into internal affairs by foreign powers all seem to entail a degree of, shall we say, agnosticism about what kind of governance or government you should have. It's up to the population concerned, the state, etc. So in a sense, if there is a conflict between democracy and authoritarianism, the first impression you get from law, textbooks of international law is that it's kind of, general international law is quite neutral. It applies laws of neutrality in that conflict between the two. If that were true, if that was the end of the story, I wouldn't be standing here today and say, because I could just leave and say, look, general international law respects sovereign equality of states, self-determination. Beyond that, particularly in the world we live in today, a little difficult to basically draw general rules applicable to democracy and authoritarianism. So let me just say that contrary to what the impression I may have created now, international law is not indifferent. It's not indifferent to issues concerning internal political organization. And I will try to, while preserving the idea of constitutional autonomy. I'm from Norway. We decide in Norway what to do with our governments or constitution and the like. The US, same. Canada, China. However, I think a lot has happened which has a bearing on those issues, and they're pretty fundamental. So let me start by doing what many do when they look into a legal issue. First to try to find some guidance in textbooks, right? Sean Murphy's books are excellent. First guidance. Then very quickly you go to see whether there are some judicial decisions, International Court of Justice, for instance, that may shed light on the problem or the issue, because the International Court of Justice in The Hague, in the Netherlands, is of course the highest judicial body of the United Nations, and they may have something to say. So what has the International Court of Justice said about this? 1975, the Western Sahara Advisory Opinion issued then, I quote, "No rule of international law in the view of the court requires the structure of a state to follow any particular pattern, as is evident from the diversity of forms of the state found in the world today," unquote. So that was 1975. Then, 1986, when Nicaragua had, it was stated that Nicaragua had taken significant steps towards establishing a totalitarian communist dictatorship, the International Court of Justice stated in its judgment in 1986, and I quote, "Adherence by a state to any particular doctrine does not constitute a violation of customary international law. To hold otherwise would make nonsense of the fundamental principle of state sovereignty, on which the whole of international law rests, and the freedom of choice of the political, social, economic, and cultural system of the state is linked to." So again, international law, you get the impression that it's a protection against external interference, and it's very much up to the legal order, of the domestic legal order of the state concerned to implement the governance, one wishes to say. But then the court, the International Court of Justice, in the case concerning Nicaragua, stated also something quite interesting. There is a possibility, and I quote, of a state binding itself by agreement in a relation to a question of domestic policy, such as that relating, surprise, surprise, to the holding of free elections on its territory. The court cannot discover, within the range of subjects open to international agreement, any obstacle or provision to hinder a state from making a commitment of this kind. A state which is free to decide upon the principle and methods of popular consultation with its domestic order is sovereign for the purpose of accepting a limitation on its sovereignty in this field. Then, very, very interesting, this is a conceivable situation, I quote, for a state which is bound by institutional links to a confederation of states or indeed to an international organization, unquote. Okay, so this is a strong signal from the International Court of Justice of saying, look, maybe first blush, there are no universal global rules about how to organize best possible way the internal governance of a state. However, we note that there may be possible ways of voluntarily joining, maybe even in some cases, an international organization or a club of states and conclude some or incur some commitments or obligations. So this is the first element I would like to share with you, that international law is extremely interesting. You start zooming in a little down from the universal global levels down to the regional levels. And I would like to share with you that a lot has been happening there, which is not limited to individual regional groups or continents, because there's more and more communication between those regional organizations and groups. There is cross-fertilization, dissemination of ideas and experience. Lots of new knowledge that has been gained in this particular area. Then I will try to explain to you, at least propose to you, that international law has been changing in terms of integrating references to democracy in very particular ways, which I think are important today and supplement what the International Court of Justice said in 1975 in Western Sahara and 1986 Nicaragua. And those are very, very important. What direction are those? What is happening here? What direction does it take? And I would like to ask you at the outset now to, you don't need to close your eyes, but imagine travel in time, you go back to 1933, visualize that you were in Europe, visualize that you might be in Germany, 1933, that's the year where Adolf Hitler took power based on elections. What was the situation then? Well, a generation of Europeans had been decimated by the First World War, and please do not forget the fact that they didn't have COVID-19, but it had the Spanish flu, a pandemic which had basically decimated a large number of people. On top of that, many things happened in the 20s and at the end of the 20s with regard to the great crash on Wall Street with cascading consequences for economies around the world, social conditions, supply failures, shutdown of businesses, mass unemployment. In Russia, there was the Bolshevik revolution and profound change there, and the turn towards, I would say, missing out on a democratic turn, because first you had the Leninist, Vladimir Lenin, the authoritarian regime, followed by civil war, and then Stalin with the totalitarian system. 1933, Ukraine had experienced the horrible Holodomor, and Stalin was on the verge of unleashing the Great Purge in the Soviet Union. Okay, so there was a sense of deep insecurity, anxiety around, particularly around Europe. And in such periods of time with anxiety, you see fear generating polarization and possibly also extremes. So you could see extremes claiming in the political spectrum that they were representing the people, or at least they were representing the interests of the people, from the far right to the far left. Let me say that this is, I think, a very important factor to take into consideration in international politics, and it has a bearing also on the development of international law. I'm very much inspired by the famous inaugural address of President Franklin D. Roosevelt, where he asserted the only thing we have to fear is fear itself. And if you remember what lay at the basis of the idea of the United Nations later on, in 1941, Roosevelt and Churchill met, and in the Atlantic Charter, they had a program of work where they stated that among the things they wanted to ensure after the Second World War was over was freedom from fear and want. So the notion of fear in politics, I think it's pretty important. Now, why am I saying this? Because back to 1933, there was a famous law faculty, a law school in Germany, in the city of Cologne. At that particular point, the year where Hitler had taken over, there was one professor who was Hans Kelsen, who is more famous today for having basically written about legal theory in ways which I don't need to go into here. But he was heavily engaged in discussion as to how to promote democracy in reality. And after the Second World War, he came, in 1933, he lost his job in Cologne because he has Jewish roots. He moved after a while to the United States, and in the United States he did a number of interesting things, but the key concern he had was, how do you promote democracy in reality? In 1933, he also had Carl Schmitt, who came to the University of Cologne. Carl Schmitt was assumed to be, after a while, the main intellectual force among those who were supporting Hitler and the Nazis. And I won't go into detail there, but you could say there was a clash of ways of understanding the world between the two. You could say Carl Schmitt was basically saying, look, the law is fine. However, there may be situations where you have a state of exception. Things are so particular that you have to basically allow for fundamental change, which is not to be decided by judges. While Hans Kelsen was basically saying that is not possible. You have an interplay between democracy and rule of law. So what happened was basically, I think, that the two, I mean, this is not to discuss 1933, but the situation of those two professors is extremely interesting, because what has happened later on in Europe, I think I can say in Africa, on the American continent, and at the UN, reflects the idea that it's not possible to discuss democracy alone. You have to relate it to rule of law, it's not only just an issue of having elections. You need to have a legal system which ensures that democracy can actually be affected or work. And that calls into play a number of things, including independence of courts and factors which have to do with rule of law. And I would add human rights. So let me take it step by step. The Berlin Wall fell in 1990. In the wake of that, December 1990, UN General Assembly issued a resolution. Remember, that was the end of the Cold War, with a feeling of, okay, we are now entering a new era, very optimistic area, where one actually managed to adopt a resolution 45/150 to enhance the effectiveness of the principle of periodic and genuine elections. So there was not a question of calling into question each state's sovereign right to freely choose and develop its political, social, economic, or cultural systems, but one had to do something to bolster these possibilities in reality. 2005, at the United Nations, a World Summit addressed issues here, which basically highlighted in a very interesting statement, which the heads of state and government rallied behind, linking democracy to rule of law and human rights. So, in parallel, you have what is happening in different regions. The Americas. The Inter-American system is possibly the oldest regional organization, and I think it's absolutely fascinating to see how early one developed thinking here, which ended up in the Organization of American States and in the notion of, in 2001, the Inter-American Democratic Charter. The question was, how can we promote things, the notion of high-quality electoral observation missions? Your continent was spearheading high-quality observation of free elections. I would like to also pay tribute to a former colleague of yours, Thomas Bergenthal, world famous. I mean, I think he was dean of this school.
American University Law School.
American University Law School.
He was a full-time professor here after that.
After that, okay. Anyway, I connect him to you mentally to your university, and in his various capacities, he played an enormously important role to promote democracy. The African Union. In 2013, the heads of government issued something called the AU, the African Union, 2063 Agenda, the Africa we want. This was not an idea which generated in the West or in North America or in Europe. It was homegrown in Africa. And the key aspirations included an Africa of good governance, democracy, respect for human rights, justice, and rule of law. And interestingly, the argument was that if you promote democracy, participation, linked to human rights, this is also a direct bearing on the right to develop, sustainable development. There's a need for a political culture whereby change of power must be based on the holding of regular, free, fair, and transparent elections. And all of that is key to prosperity, development, participation. Europe, and I'll soon end up there, say that we have, because of the horrible history of Europe in terms of extremes, wars, and other things, it was a huge project after the Second World War to try to promote international organizations that would sort of prevent backsliding of democracy, etc. Council of Europe is the first one of them. And today it has 46 member states. Russian Federation has been excluded from the international organization because of the latest events. 46 member states out of 193 member states of the UN. It's a considerable number of states. I would draw your attention to a declaration by the heads of government of those 46 states in May of last year, May 2023, in Iceland, the so-called Reykjavik. Reykjavik is the capital city of Iceland. The Reykjavik Principles for Democracy, to prevent democratic backsliding and stand firm against authoritarian tendencies. What do they say? They say that principles of democracy, rule of law, and human rights are interdependent. You cannot isolate democracy from rule of law and human rights. Democracy, and I quote, is considered the only means to ensure that everyone can live in a peaceful, prosperous, and free society. And there's a program of work. Let's see to what extent it can be followed up in practice, but the heads of government basically said there are 10 elements here. I will just concretely mention some of them. First key factor of success criterion is the holding of free elections, free and fair elections, democratic participation. Immediately following that, number 2, the 3 key freedoms: freedom of expression, freedom of assembly, freedom of association. If you don't have those, difficult to basically organize what is necessary in order to prepare for free and fair elections. Third element, independent and effective parliaments, which may include the need for ensure high ethical standards for members of parliament. 4, separation of powers, to prevent any excessive concentration of power, I quote. 5, independent, impartial, and effective judiciaries, free from external interference, including from the executive. 6, fight against corruption. 7, of particular importance to us all, and you in particular, academic freedom, free media, and nowadays, particularly the need to counter disinformation and misinformation over social media, the internet, etc., etc. Eighth element, invest in a democratic future by promoting inclusion and participation of young persons in democracy. 9, a civil society is a prerequisite for functioning democracy, and we should support human rights defenders. It's important. Finally, last but not least, full, equal, and meaningful participation of women and girls, and then fight against any kinds of discriminations on any grounds. Those are great ideas, but it's interesting to see that it's impossible now in Europe to discuss the issue of democracy without linking it to prerequisites of success of democracy by highlighting the interface, the interdependence with rule of law and human rights. So in the wake of that, we have discussions, or prior to this declaration that was issued, many different contributions, which I think are also the object of cross-fertilization exchanges with US universities, with various institutions in the United States. What can judges do to promote protection of human rights, which are vital to preserving democracy? Courts have a role to play when it comes to, for instance, ensuring freedom of expression. They are so-called public watchdogs. That's the expression used by the European Court of Human Rights. Secondly, freedom of assembly and association. That's something where courts, with judges, can actually be key. Third element, still for judges, electoral rights and democracy. That's something where judges have a role to play. And finally, extremely important, independence of judiciary. The idea there is that if you don't have free or independent and professional judiciaries, you cannot have the trust which is necessary in society, not only for expressing yourselves and participating in free elections, but if you don't have independent judiciaries, it's pretty risky also to invest money in a business. Without judiciaries, you cannot really, the word credit comes from Latin. It means to believe in, to have faith in. Fiduciary instruments, fidus, that's trust. So at the end of the day, the issue is you need an infrastructure, an invisible infrastructure, sometimes visible through the presence or existence of courts and a few other things, free media. You need those, because fundamentally, those are guarantors of the necessary trust to ensure that things work. I will end up and now open up for discussion with you, because I'm pretty sure you have views, and there's lots of other things I could say, because I must say I was a little taken aback by how much one could discuss democracy. Remember NATO, the North Atlantic Treaty, 1949, it has in its preamble the reference to being founded on the principles of democracy, individual liberty, and rule of law. And we could go on like this. We could discuss social media and other things. But let me just say that I was, until recently, ambassador of Norway to the European Union. And there's a big discussion there. Norway is not a member of the European Union, but we are very closely associated with the EU through being part of the internal market, Schengen, liberty of movement, and a number of other things. And we have a common conversation going on how to promote democracy, civil society, rule of law, by ensuring that if you have funding for certain purposes, let's say money that is to be used to promote green shift, to get rid of use of fossil energy, for instance, clean up environment, or if you have money being dispersed in the wake of COVID to rebuild some sector, could you put conditions to those governments who would be receiving European money or funding? And the key notion there is conditionality. This is linked to a kind of insurance policy against authoritarianism. Because if you see some of the key criteria for successful democracy being jeopardized, you have to really think early and not too late about what you can do in a modest way, possibly, but to promote a course of action through governmental priorities which takes on board democracy. So I will end up by saying that I did not mention Asia in particular when it comes to the debate about democracy, etc. But there is in Asia not an international organization such as the OAS or the EU or Council of Europe or European Union, but there is in a number of Asian countries a very rich discussion about democracy and rule of law and development of ideas which are quite phenomenal with huge positive results. I also take a lot of interest in legal history personally, and I've been looking at how one is arguing in the big democracies in Asia as to the legitimacy of certain things. And I'm pretty positively impressed by the fact that one doesn't care really as to whether good ideas and thinking stems from one's own country. It could be that it comes from North America, from Europe. So in a sense, I think we are moving towards what I started by saying, adding democracy to some of the, what should I say, objectives which have now been firmly grounded in the discourse of the United Nations and variety of regions, with different speeds. Because in some cases one has gotten quite far, in other cases it's a budding experience, and in some cases one hasn't had much time to consider these things. I think in North America and Europe, as opposed to 1933, which is kind of was a terrible year in Europe, we have a totally different situation in North America and Europe and in a number of other countries around the world on other continents, in that we have long-standing institutions which are resilient and with lots of experience, and therefore much more robust and less exposed or vulnerable to sudden shifts which would lead to despotism or authoritarianism. However, there are many ways of measuring democracy. I've noted at least 5 which are in enormous sort of laboratories of understanding how can you assess the actual developments of democracy around the world. And it can be sort of divided into a degree of very sophisticated ways of measuring things. Like at the University of Gothenburg, there's a particular project which basically studies extremely carefully a number of developments. And if you do that, you will see there are some developments where you can see some backsliding on democracy, it's clear. And authoritarianism, that's absolutely clear. And what is going on now with regard to conflicts, Russia-Ukraine, I won't enter into that. It's not my aim here, but clearly, we cannot take democracy for granted. And what I'm trying to share with you is that international law, general international law, is now being inspired by quite a lot of what is happening in regional fora, but there's also a common listing of key documents that highlight the pertinence, the relevance of democracy for all the other values that international law is meant to protect and cherish, from peace and security to sustainable development and protection of the environment. So thank you for your patience and attention. And now I'd like to hear more from you as to whether you have views or comments, or if you fundamentally disagree with me on issues.
Well, thank you very much, Ambassador Fife, for those comments. We do have about 20 minutes or so for questions from the audience or comments. I might make a couple just to break the ice. There's some interesting literature now here in the United States that goes under the rubric of authoritarian international law. And the idea there, I think, is where you started your remarks, that international law, to the extent that it's neutral, in the way it approaches countries might provide an opening for authoritarian regimes to use international law to help solidify their own, existence and push away, international institutions to the extent that they seek to change it internally. So I think your remarks are an interesting, perhaps pushing back against that notion. The other thought, I had a professor when I was studying international law as a student, Louis Henkin, who often said that he thought international law was not for the saints and not for the sinners. It's for the ones in between. And by that, I think he meant the saints, probably had Norway in mind when he thought about that there are countries that are probably going to basically do the right thing, consistent with international law, but they would do it even if the international legal system wasn't there. There's the sinners. We probably all have our favorites. I'll just throw out North Korea as an example that is pretty difficult to have international law get traction to change them. But his idea is that international law, has a role to play with these ones in between that might be a little bit on the margins. And it seems to me your remarks speak well to that possibility, that there's countries where democracy versus authoritarianism a bit in flux, and maybe there's a way of using international law and institutions and the funding that can go with it to steer things in one direction or the other. Does that make sense to you as a way of thinking about it?
Absolutely. Thank you, Sean, Professor Murphy. What strikes me is that international law, as such, was also a common grammar that should be the fundamental language that makes it possible to conclude agreements, resolve problems, irrespective of fundamental differences of worldviews, ideologies, etc. So there's a very important part of international law, which is basically to have a universal grammar whereby you have precision and a toolbox so that you are able to basically overcome disagreement. How far one can go depends, of course, on a number of factors, but I think that's one aspect. That doesn't mean that international law is only a common language among very widely different kinds of legal systems, because I think that we have seen over time, and I mentioned some examples of UN or other World Summit documents that highlight how much knowledge one has gained from the economic, social, environmental, and peace-related advantages of including democratic participation. And I stand to be corrected, but I have not found many governments or states who do not invoke the interests of the people. You refer to North Korea, it's formerly the Democratic People's Republic of Korea. So in a sense, democracy as a notion, of course the contents may be very different interpretations about what they mean, those concepts. But the mere fact that it is now becoming part of the mainstream discussion, irrespective of ideologies. Whether it's from one extreme to another, one is speaking either on behalf of the people or in trying to promote or protect its interests, quote unquote. And that's where I think that deconstructing a little the issue of democracy and just not limiting it to the phenomenon of free elections is very important. It's connected to an environment, a legal framework of norms and institutions and transparency. And there's been a lot that's happened, which I think means that we have a very different situation now than in the 1930s in Europe, for instance. Does that mean that things are perfect? Far from it, but there is, in terms of international law, a grammar that has developed. So it's not just, I don't think that at the UN it's practically possible to argue by saying, oh, you used the D word, you talked about democracy. Of course, some states will say, we don't want to be lectured by you as to the kind of democracy we want to have. And we have a fundamentally different view of that. But I haven't met many who, or actually I can't recall anyone who's saying that democracy is not the premise, the litmus test for success. And that is quite different from a few years ago. So that's a sort of note of optimism. But it goes to saying also that it's not international law alone that can resolve all those issues. But international law is moving. And I think it's, again, in terms of toolbox for problem solving, particularly in tense situations, a very powerful instrument because it's a kind of common language that can be used. And you use a particular concept, okay, people, states might interpret them in different ways, but there is an overwhelming amount of clarity by external analysis and discussion, which has stabilized quite a few notions. And I think that's one of the roles of not only coordinating governments, but also of promoting more coherence and overcoming disagreement. It's very difficult to agree on a treaty or a text if you're not entirely sure about what words mean.
Questions from the audience? Sierra.
So, thank you for the lecture. First of all, as we know, 2024 is a big year for elections. A lot of elections taking place in the world right now, or will be in the next few months. And a bunch of countries will be electing de facto, I don't want to say dictators, but very authoritarian people, just throwing examples such as Russia, Venezuela, and countries like that. I've thought about it, and I can't really find an answer to it, but how would we be able to deploy international law to sort of help democracy and to sort of help increase democracy or democratic elections in those countries, given that international law has a very delicate role and you cannot interfere with sovereignty, the principle of non-interference, and such.
It's a fundamental question. It's a very good question. Now, I think I take a lot of reassurance in the fact that many of the institutions that have developed and that are scrutinizing those issues, they're not sort of narcissistic or inward-looking. Most of them are referring to the need to cross-fertilize and have discussion with similar institutions elsewhere. And I think that the internet and possibilities of interconnectivity, well, of course, they create additional problems in some cases. But it's so much easier to cross-fertilize and compare notes and ensure transparency. So people, institutions connect in a totally different way now than they did like even 20 years ago, 10 years ago. So there's something called, for instance, the Venice Commission, which is part of the Council of Europe, which is a high-quality body which scrutinizes individual constitutional systems in Europe based on the assumption that, okay, kind of governance that country wishes to have, that's their business. However, we will certainly look into the criteria of, well, pertaining to what we have been discussing. And they have, to an increasing degree, put an emphasis on the need to cross or compare notes and exchange with other institutions, whether on other continents, or also take on board the input from various other bodies. I would, in that context, also say that I have the highest respect for human rights defenders, for journalists. Journalists are pretty exposed in many cases, and there is a huge degree of interconnectedness between those who are very worried about some of the developments we see. Now, I have been following in particular the fact, that in the EU you have the European Parliament, which has 750 members. They're going to have huge elections in June, and there's a big focus there on whether there are some shifts in the perceptions and public opinion in many European countries, members of the European Union. because of a variety of reasons. And I think that's also something which gives rise to a very interesting debate on what is actually happening in real time. It's not like we're doing historical studies of what happened 10 years back. It's while we speak. And how do courts actually work? How do the media, how free are they? How do the youth look at elections or politics? Have they an interest? Do they take an interest? Or do they basically give up or not? All of that is a very lively conversation and debate. And I think it's a vital one. So I would basically speak in favor of well, I'm European, I would say to European colleagues, do not only look to European Court of Human Rights, do not only look to the Venice Commission, look also at what is happening in the inter-American sphere, look at what is happening in the African Union, look at what is happening in India, etc., 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 and then see to what extent one can cross-reference and contribute to a common understanding that this is just not a culturally limited phenomenon linked to a particular continent or country. Because I think there's a parallelity, an interconnectedness, which is pretty strong, pretty strong. I don't know if I answered at all, but it's just, the question was very good.
It's a tough question.
It's a tough question.
Arvid.
Thank you for the really thought-provoking lecture. And the conclusion left me a little wondering, or because it felt a little counterintuitive to me, because you're basically stating this really optimistic view that now democracy is some value which is somehow at least a little bit being introduced in like the international law sphere. On the other hand, as already mentioned, we're seeing this huge democratic backsliding, like, or authoritarian backsliding all around the world in like countries which have actually strong democratic traditions and history. And so I'm wondering, like, those two, it doesn't fit to me. Is this like, this having like democracy being introduced in the international sphere, is this like a reaction on this authoritarian backsliding? Are those maybe some loud voices from some really democratic countries which are like Sarah just mentioned, we have to do something, maybe on another sphere now, or how does this fit?
That's a very good question. My only point here is basically to say that the grammar of international law is developing, I think. International law doesn't resolve all those questions. But we should basically, as people who are interested in international law, promote as much, what shall I say, interaction between the domestic legal orders, international law, regional law, etc., to the extent that the law or international law can contribute. But then there are quite a few other things, and there's issue of there are many policy issues and economic and other factors which come really into play, and we haven't really discussed technology, but you know the role of corporations in basically in the governance of the digital communication is enormous. So I would be amiss if I didn't say that there has been a very interesting discussion as to what role corporations and responsibilities corporations may take in order to promote things. Now we could say, okay, it's not easy and it's maybe slow, but it is quite consequential if a particular social media or a platform takes seriously a phenomenon or does not take seriously such a phenomenon. So it's not only governments or states that can contribute to democracy and prevent backsliding. It's something which, not least major or big corporations, which have an influence on the infrastructure, which is key to freedom of expression and etc., they have a role to play too, but that's just a few examples. So you have a very good point, and my only defense is that you cannot blame, I think, international law for lack of progress, because international law is not anymore, in my view, a system which is totally indifferent to or agnostic about democracy. And there are hearings and consultations and examinations in various human rights bodies and many other places where governments appear, defend themselves, and there's no one saying, oh, democracy, no, that we cannot, we will not respond to that. Of course, they will be sensitive to what kind of democracy one is talking of, but you don't have to go that many years back in time before people say, no, this is internal stuff, and you cannot interfere with internal affairs of my country, the UN or whoever, Article 2, Paragraph 7 of Charter, etc., whatever comes into play. We are much beyond that. Of course, the phenomenon is still there, but it takes on a new semantics, a new way of expressing resistance. But there's more transparency now than there was before.
Yeah, thank you very much, Ambassador, for this extremely rich presentation and also this positive perspective. I was wondering, so I think one could argue that there is a certain increased resort to international courts and tribunals, and also with regards to community interests such as the legal obligations with regard to climate change, but also ongoing armed conflicts. So would you, this perspective maybe view in relation to enhanced integration of the domestic and international, or how would you see that?
I think the answer is yes, yes, yes. That I was. Let me try to answer in a very oblique way and hopefully get there. In my former job in Brussels, it struck me that most of the issues that we were discussing with the European Union had to do with global issues. You know, whether it's a pandemic coming from another continent, or it's something relating to invasion of a country somewhere, or you know, the list is pretty long of issues which are global in nature. So the interconnectedness between systems it struck me as fundamental. So I very seldom didn't benefit from having some kind of idea about international law when discussing European issues of migration, what's happening in the Mediterranean, or whatever. The interplay between global systems. Said Mediterranean, what about refugee conventions or human rights instruments, other things? The regional orders, where there exists regional orders, but also the national legal orders. So, you know, in international law, and you are privy to what has been happening over several years in the Commission, Sean, but, you know, we are very hungry after, we want to detect state practice. What have states actually been doing? Can we build something? Can legislation and jurisprudence and things that are developed, case law in various countries, can they provide us a picture or basis or building blocks for saying, hey, we have a budding norm of international law, maybe customary, etc. So we are running around like foxes trying to identify state practice. And in a number of states, when developing state practice, one is doing the opposite. In my own country, I remember as legal advisor, before on a number of statutory law initiatives taken or domestic legal instruments, we say, hey, before continuing, we have to look at little at is there anything we can draw from existing international organizations, from norms that have developed or are being developed as we speak? What about regional levels? Basically, it means that life is, the world is more complicated than before. There is a dialogue between systems, and understanding systems, and I think is key to a number of those issues. Now, some problems you allude to have to do with anything from horrible, even armed conflict or the like, but you can also have, well, imagine that some issues will be exacerbated by climate change or by pandemics or by disruptions relating to cyber activities, or So what I feel very strongly is that it's an important job for us all to basically promote an understanding among governments and civil societies of the interconnected vulnerabilities we have. We are well served by international law. International law is not something which is limiting us. It's actually in the national interest of quite a few states, if not all. And there should be costs, transactional costs, in being perceived to basically disregard fundamental international law. So what I see is that in European institutions, there's more and more references to international law, general international law, etc. Maybe they're not necessarily explicit, but it's there. And in national law, there's more and more reference to other legal systems. So if I should venture kind of guess, it is that we will need to adapt the solutions we adopt in different states to local realities, our own different legal cultures, the different ways of resolving particular issues. But this is understood as being part of a broader system. What is very problematic is if we see a major backsliding of, you could say, democratic and rule of law related issues, because I think it undermines the fundamentals of trust and relevance, because you will sort of have more and more separate circuits of exchanges of idea and not the rich interconnectedness we still have to a large extent. The more interconnected we have, the more dangerous the world is in some ways, but it's also the richer exchanges of ideas that are possible. And I think that's a fantastic time to live in that sense, because the possibilities are enormous. The pitfalls are also quite huge. So this is very philosophical, has not much to do with international law.
It's not a bad way to end the conversation. I think we are about out of time, but I really like the fact that you took us back to 1933, because I do think that having a historical perspective on where we are now is quite important. And I wonder if part of the optimism that you have and I share is, we grew up, we were the age of most of you at a time when there was the East versus the West, right? And I remember hiding under a table in kindergarten because that's what we were supposed to do when the nuclear bombs hit, right? And apartheid is in full swing in South Africa, and we've got a Berlin Wall, and there's all this stuff going on that at the time felt like it would never change. But we saw it change, and it all changed for the better. And maybe that's partly why, as bad as the world looks today, in many respects, it can change, and it's going to be on the watch of most of you that it may well change. And we shouldn't think about history as a progressive, every time getting better, linear movement. There are dips. Maybe we're seeing a dip in retrenchment on against democracy right now. But I like to think it's the kind of thing that international lawyers and policymakers can make a difference in trying to bring it back. So that's up to all of you here in the room to take on as a charge. Anyway, please join me in thanking Ambassador Fife for the
Thank you. That was great. Questions were so much better than my arguments, because it was quite difficult to.